Welcome to the Ahaki podcast. On this series, we focus on what does it mean to litigate issues of sexual reproductive health and rights in African courts. We're sharing experiences from different countries and beyond. I'm Solomon Serwanja. Welcome to this particular episode where we are privileged to be hosting Honorable Justice Mandala Mambulasa, who is from the High Court of Malawi. Honorable Justice Mandala, thank you very much for taking time to be on the show. Karibu sana.
Thank you so much. And I'm happy to be in Uganda. I consider Uganda to be my second home, having been trained here at Makerere.
Oh, you went to Makerere University?
Yes, I was at Makerere for some 4 or 5 months on an exchange program. So, yeah.
How did you find it?
Great.
Great. Thanks for coming. Let's start with you put on robes. You are on the other side. We've been having people on this podcast who have been on the other side. People are the lawyers, the attorneys. We've heard from civil society. And now it's really wonderful to hear from you as a judge. What has it been like for you hearing these cases around sexual reproductive health and rights in the High Court of Malawi?
Okay. I am in the civil division in the High Court, and that's where you get many of these cases. I also serve in the family and probate division, and that's where you are likely to get these cases. But so far, since my appointment in the year 2020, I have handled maybe 2 or 3 cases relating to these issues. I can't say more about them because some of the cases are still pending. But we do have a few cases on sexual rights and reproductive health. So I think for now, let me stop there and say that we do have a few cases that have come and are pending before the courts. Of course, some of them not directly related to sexual reproductive health as such, but in form of negligence, medical negligence, but still eventually would touch on issues of sexual reproductive health and rights.
Okay.
Yeah.
How would you describe the legal and policy framework in the Malawi law in as far as critical issues on sexual reproductive health and rights?
In terms of the constitution, we have a liberal constitution that guarantees human rights and freedoms under Chapter 4 of our constitution. But the right to health is not a justiciable right as such. You find it under the directory principles of our constitution, which the courts are supposed to have regard to. But lawyers are being creative. They would link them to right to privacy, right to life, which are justiciable, and therefore, although it's in form of directive principles, in that sense, one can argue that they are still, or the right to health is still justiciable, especially if you link it to the other rights that I've talked about, as it has happened elsewhere, like in India and other places. Coming to statutes, we have the Public Health Act, but very old, I think, dating back to the 40s, if not 60s. It currently went under review by the Law Commission, which is an equivalent of your Law Reform here, Commission. But it's yet to go through the other processes. In terms of policy, we have a number of policies on these issues. We have a sexual reproductive health and rights policy by the Ministry of Health, came to expired, of course, in 2022, and they're working on a new one, but provides for comprehensive and integrated SRHR services. We also have youth-friendly policies on these issues. So in terms of provision of service, I think I would say that we are doing well. We are doing very well on that. So we also have STI clinics in various hospitals across the country, both public and private. So in terms of access, I think we are doing fairly well, and implementation.
Let's touch on one of those core issues around Africa that have been controversial in our legal books, and that is the subject of access to clinical abortion.
Yes.
How is it like in Malawi?
That one, it's we have a restricted regime. Abortion may only be allowed on certain grounds, I think, under our constitution, under our penal code. Very limited, where there's threat to the life of the mother. You may, but we don't have a liberal where you can go and just want to have abortion as a matter of right. Those we don't have. There was an attempt to have legislation in that regard, and there is a report by our law commission proposing, but it has not seen the light of the day because people still don't agree with some of the provisions that are in that report and bill. So as we speak, we are still stuck by what is provided under our penal code.
Penal code.
Yes, and a little bit of it, some people are arguing also in the Gender Equality Act that there may be room for you to maneuver, because that legislation specifically provides for SRHR services. So maybe, and if we go by the Maputo Protocol, one issue would be that we should have these services, but it's difficult in terms of implementation because of the provision now in the penal code.
It's interesting because the subject of the penal code has been one that has started to be discussed across Africa, whether the penal code represents us as African people or it was just an imported law by the colonialists. What would be your general thought around Africanizing our laws?
I would say that in the context of Malawi, we have had reviews to our penal code, a number of them. I think the last one, if I'm not mistaken, was in 2012. And these provisions have been retained as representing the views now of the people. So we may have inherited, but through the processes that we have gone through of review of the penal code, many of these provisions have been retained. So in a sense, one would argue that now we own what we inherited, now we have made it to be part of our...
We've qualified them as
yes,
part of
precisely, yeah. So I think that's what I would say for now, from what I know.
You see, and that's a thing that is happening. I mean, I've interviewed people who have said,
yes,
these laws were made somewhere,
yes,
in the UK or even in India and all that, and that came in as common law, and it was pushed down our throats, and maybe it's time for us to start to decolonize our laws, so to speak.
Yes.
And that narrative is also not only happening in the legal fraternity, even in the academia.
Yes.
A lot of the
True.
work that we recite or that we cite in our research papers is so much work that has been done with Eurocentric ideology. And people think it's time for us to own our own work.
Yes, I would agree with those sentiments, but in our context, unfortunately, if I may put it that way, we have had a chance to review, and somehow some of these provisions have been retained. Yeah, because of the context in which we operate, cultural, religious, and so, yeah. People are not convinced yet. Maybe we need more awareness, more research, provide information, But we have serious challenges of maternal mortality. If I remember very well, we are at, I think, 439 per 100,000. That's still a lot. Actually, no, if you ask me, no woman should die for giving birth. But, you have also our health system being, overburdened by post-abortion care. And when this information is presented to policymakers and authorities, somehow we adopt an ostrich approach where we want to bury our heads in the sand and still, proceed as if everything is okay. But unfortunately, like in our case, we're on the receiving end. So there's not much that one can do until when maybe cases come and these provisions are challenged. But as we speak, that's the situation on the ground.
As I was listening to you, I know that's the same thing that's happening in Uganda. We have crude abortions that happen backstreet.
Yes.
And our health system is really, really burdened by the post-abortion care, especially in many of the national referral, but also the regional referral hospitals.
Yes.
We spend a lot of money to treat people who are going to do crude abortions, and yet our legal framework is restrictive in terms of access to clinical abortions. Yeah. And there's overwhelming evidence. There's these numbers that it's happening.
Exactly.
But they are...
in our case, we have even received the recommendations from CEDAW committee on these things to say it's high time maybe you changed course, but somehow it's difficult. It's difficult for women to have the full freedom and autonomy and to decide what is good for them. Somehow, these decisions are made by other people.
Just like in Malawi, we've presented these facts to the legislators. We've said, look, these are the facts here. But many of them put on the lens, the culture and religious lens, and sort of blind themselves to the facts that are presented. And every year, these facts continue to present. And this data is by government agencies. It's facts. And this is where we think that the judiciary as a whole needs to give some sort of guidance. We've seen scenarios where the judiciary does not wait for the legislature, but they come on board as a separate independent entity to give some sort of direction and guidance on critical issues such as these. I don't know what the place of the judiciary in Malawi looks like, but there's increasing pressure from the public that while the legislature that is supposed to make up these laws continues to blind themselves to the facts and evidence, the judiciary needs to come and give guidance on some of these things.
Yeah. Maybe let me go back to the point I made earlier on about women dying. You find that actually it's rural women, it's poor women who are the most affected, who are hit by these things, because well-to-do women can go to other countries and get services, and even can afford to pay for them, even within the country. Yeah, so it's sad. It's sad that it's poor, vulnerable women who are mostly hit by this. But in terms of the judiciary, remember that we have to be moved. We have to be moved for us to deal with the matter. So it is incumbent upon lawyers, upon civil society organizations, upon individuals to move the courts and seek appropriate remedies for the courts to be able to give guidance. We can't just give this guidance in the air. So perhaps cases, we wait until cases are filed, and when that opportunity comes, that's when the courts may pronounce themselves on these issues.
In Uganda, for example, the Makerere University Law School has, presented, has come on board for different cases as amicus curiae, and they're saying, look, we feel that, as the holders of, or the implementers of the law, we need to give direction and guidance. And therefore we instruct that courts do not just, I think there's a ruling that was very significant in this country, that courts should not just go with what the legislature is telling them, but they must be in position to make independent guidance and direction as part of government. I think there's increasing pressure that you stop to just go with what the parliament or the legislature is telling you, but make informed decisions as the judiciary to guide the country in a given direction.
Under our constitution, our mandate is to interpret the constitution and all laws made under it with regard to legally relevant facts and prescriptions of the law. So, and you know, our role of interpretation, one has to be careful so that you don't stray into lawmaking as you do your job of interpretation. So, you know, that's the premise, but I'm not saying, because the constitution has to be a living document, it has to meet new conditions, you know, that the framers could not imagine at the time they were making the constitution. There is still room that, you know, the provisions of the constitution can be interpreted in a way that can address new challenges that are meeting. But at the same time, bearing in mind that our role is really, you know, to interpret and not lawmaking as such. So how to navigate that, how to, you know, balance these two interests, I think it's what is critical. But as I said, there is an opportunity. There have been cases where, for instance, there's one case that I was part of the panel, the constitutional panel that handled it. We were able to admit Amicus Curiae, Center for Applied Studies in South Africa. We were able to admit the Special Rapporteur on the Right to Health, Madame Mofoking. We were able to admit Dr. Godfrey Gangaure, who is a specialist and a researcher in this area. When an opportunity presents itself, we were able to, you know, allow people to come and help us as friends of the court. So the few instances that we have had cases in our courts, I think the courts have been proactive. Actually, we invited the amicus. We did not wait for them to make application because we knew that the court must be accessible and to all, and that the court doesn't have all the knowledge in some of these specific areas, and that therefore where you need assistance from experts, open up and invite them to join. And we did. Mm-hmm. Unfortunately, when the decision was made to allow these amicus, the Attorney General was not quite pleased, was not happy. So he applied for a stay of the decision pending appeal in the Supreme Court. And as far as I know, the appeal was never prosecuted. And we got communication that the Attorney General and the parties have now reached an out-of-court settlement agreement. Because in the interim, our legislature has intervened and changed the law. So this was a law on defilement, and there were concerns that it was catching adolescents, and you know, so that case was challenging to say, was this the original intention of this law, that it should catch adolescents and children should be in prison instead of being in school? So our parliament has intervened and they have since changed the law. So at least for now, children of 18 and below cannot be caught by this defilement provision. So we have made headway. But it would have been interesting to see what the Supreme Court is going to say on the amicus curiae that High Court admitted. But since the case hasn't been prosecuted, for me, I would argue that our decision still remains the law. We can admit amicus from all over the place to come and help the court. After all, Malawi is a signatory to ICCPR and all these conventions, so I don't see anything wrong with admitting
Amicus curiae.
Yes, from these institutions.
Yeah.
Yeah.
No, I think it's important that, friends of court can give their view and stand on a certain topic.
Yes,
We've
yes.
seen it work very strongly in this country.
Yes.
But let's face it, Justice Mandala, justices and judges at all levels are just but part of the social construct, that is guided by culture and religion.
Yes.
How do you maintain an independence when you're listening to these cases as judges and focus on the evidence rather than religious and cultural sentiments?
For us, we take an oath of office to do right to all manner of people. And personally, speaking for myself, I don't take that lightly. Doing right to all manner of people would require that you put aside your personal views and inclinations and look at the facts, the evidence, and the law to come up with your decision. Because the offices we hold are not meant to save sectoral interests. We hold these offices to save the public interest, and therefore it's something that every judicial officer must overcome time and again. We all have our excess baggage that we come with as we go to the bench, but we must always remind ourselves that yes, we belong, to society. We have certain inclinations, but when it comes to decision making, we must look at the law and the facts and the evidence that has been presented to make a decision. So it's a constant battle. You always need to remind yourself about these ideals and virtues. Mm-hmm. So I would say that, and a judge must keep an open mind, in all fairness, because you save different people, so you cannot afford to be so myopic and so narrow-minded. You need to keep an open mind, be open to new ideas. I think that's what I would say, and it's a constant battle that you have to engage with.
Yeah.
Yeah, and remind yourself all the time
that I have to be as independent
yes,
as I can.
I have to be as independent as I can. I took oath to save all manner of people and not just a certain group, and so those have to be constantly come to mind when you're discharging your functions.
Yeah,
and duties.
Yeah, I agree. In many of our African countries, just to go back, we heavily rely on laws, and I know we talked about this earlier.
Yes.
On laws, penal code, like the penal codes that still remain alive, and we use them in litigation. Do you think that we need, as a continent and different countries, we need to revisit these laws and see if they are working in the current state, and the need for us as Africans to own our legal and policy framework rather than just adopting, laws that were crafted out of this continent?
Yes, surely there is need to revisit our laws. The context has changed tremendously from the time when we had these laws. New challenges have emerged that were not there at the time these laws were passed on to us. Surely there is an urgent need to go back and see whether the laws that we have are serving our interests. If you may allow me to quote what Christ said, that the law is meant for man and not man for the law. And if the law now becomes an impediment to realization of rights and freedoms, then we have a problem. We have a problem. So it's like you now have a law for its own sake. But the law must serve the interests of the people that it is made for. And if it is not, it is the same people who must be able to visit it and change it. It's not something that is cast in a rock. These are things that are made by people, and the same people can also revisit and change them. So I would agree with you that there is need to go back and revisit some of the laws. And make sure that they are serving the interests and the new challenges that we are facing now.
Do you have any challenges in prosecuting or in listening to cases as the judges related to sexual reproductive health and rights? Any challenges from the other side as men in robes?
Yeah, this is a growing area. It's a new area of the law. We have not always had it in terms of cases. Like there's a generation of judicial officers that never did human rights. So this would be something that is strange, that is new to them. So that's one area, or that's one challenge, and that's why it's important for Afya na Haki to bring judicial officers in these kind of spaces so that we learn, we relearn, we unlearn some of the things that we have held on to, and make sure that together we are part of the new project to build societies that are equal and that are just for all. So the need for continuous engagement, the need for sensitization, the need for awareness about these new challenges cannot be overemphasized. We need to have these conversations time and again. Yeah, that's the only way that we can, make progress. I was particularly pleased last night during the dinner to hear Judge Chebron and Her Worship Msenga saying that it has taken, people like Professor Tino Mugisha, Professor Mbazira, and others to constantly engage them on these issues. And Uganda has witnessed decisions that are now being made by the courts that are in favor. Why? Because of that effort of engaging judicial officers. And I would say that even on our part as judiciary, we must also be willing to learn.
That's the thing.
Yes, we must also be willing to learn and give a listening ear to new developments that are happening in our continent and even beyond. We can't keep using old software, if I may put it that way. So many things are changing, so we need new software also to meet the new challenges that we are meeting. So it requires that we are constantly updated. We read a little more just to understand the subject matter, even on our own. And it's incumbent upon you also to share the literature you're generating, the new knowledge that you are creating, so that, we are abreast of the developments and we are on the same sort of page. Yeah,
I agree. Especially in the time like this when we have far-right judges, far-left judges.
Yeah, we are not a homogeneous group. We are different stages. So, but keep on. There's hope. Yeah. There's hope. It's a continuous struggle. We can't afford to give up. Let's keep on fighting.
Honorable Justice Mandala, thank you very much.
You're most welcome.
Being with us on the show.
Thank you.
All right. I've been speaking with the Honorable Justice Mandala Mambulasa, who is a Justice of the High Court of Malawi, speaking to us about, the need for flexibility for the people who are behind and continuously learning and unlearning. This is the Ahaki podcast. I'm Solomon Serwanja. Thanks for watching.